Hey everyone, the latest Chevron Ecuador news as of June 6th really doesn't specifically directly concern the famous case where Steven Donziger has been suing Chevron for actions that were done by Tex-Pet, the partnership between Texaco and Ecuador in Ecuador between 1967 and 1992. No, this is related but different, but it's important to know about this so that you can understand the truly cozy relationship that Texaco had with Ecuador and vice versa, as opposed to what you have been told, which is the oil company imposing itself on the poor third world country and polluting in it. Far different. This is what happened in this Ecuador versus Texaco and then Chevron case. The news as of June 6th of this year is that the United States Supreme Court refused to hear an argument by Ecuador, which was seeking to reverse the decision laid down by the United States District Court of Appeals, the DC Circuit, in 2006, where the DC Circuit had said, hey, to Ecuador, you owe basically Chevron $96 million, $106 million when you tack on interest, because you, Ecuador, failed to handle or pay attention to the lawsuits that Texaco, before Chevron, had filed against you in 1992 through 1993. Now your head is probably spinning and you're saying, Zenny, what's going on here? Let me explain further. In 1973, Texaco, which was involved in Tex-Pet, a jointly owned organization, 67% owned by the country of Ecuador, to basically allow Ecuador to gain money from oil production, learn oil production, and eventually replace Texaco's activities with its own state-owned activities and become a major world player in oil production. That was the idea. Okay. Now, what happened was that as part of that 1973 partnership, there was an agreement, a contract, such that Ecuador will receive oil for its domestic use at below market rates. When Texaco was about to wrap up its partnership, its Tex-Pet partnership, the ownership of Texaco, its percentage went from approximately 34%, I stand corrected, 34% to somewhere down around 19% over that period of time. And in 1989, Texaco had basically no involvement in what Tex-Pet was doing at all. So they were wrapping up the relationship. But in wrapping things up, the Texaco executives discovered that, hey, you know, Ecuador had been drawing down more oil than it really needed for domestic use by large chunks. Ecuador basically, for want of a shorter story, ignored the lawsuits. And then when Chevron took over from Texaco and took a look at this case again and refiled to get its damages straightened out, Ecuador's argument was, hey, we didn't have an agreement with you, Chevron. We had it with Texaco. And therefore, we're not violating the terms of the bilateral investment treaty. But the DC Circuit said, no, 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 no. The simple fact that you, Ecuador, had the agreement with Texaco and all of the requirements within that was enough to enforce the contract and find that you were in violation of the contract and find that you owed those investors monies. The basic rule is that If U.S. investors have a claim against you, and it was done before the bilateral treaty was established, they still hold. Got that? So 10 years later, this was brought to the Supreme Court this year. The Supreme Court said, we're not going to look at this. We're going to let the lower court's decision stand. So Ecuador owes Chevron $106 million. That's the story.